our last segment for today, we're talking about which VA disability cases tend to be the hardest for claimants to win. We're going to talk a little bit, kind of in rapid fire style, about why they're difficult and what kinds of evidence or preparation can really help to make the difference. We're going to be talking about cases that are difficult to win. In no way are we saying that these are hopeless or unwinnable. That's not true at all. If you feel like you are dealing with a hopeless or unwinnable case, I bet you that we can convince you otherwise. Usually these cases are defined by a quirky or very involved legal standard or a very specific evidentiary burden. So hopefully going through some of the hardest things that we see in our practice will help you understand if you're dealing with a particularly complex case that might need some extra attention. So let's first start with clear and unmistakable error. Clear and unmistakable error cases are very difficult to win because they require satisfying a very complex legal burden. So a motion for clear and unmistakable error is one where a veteran might say a decision that was made a long time ago that was never appealed was clearly and unmistakably wrong, and that VA should correct that error. These errors have to be undebatable. They have to be things that no reasonable person could view differently. They have to be very obvious errors. So it can't just be something where one person sees it one way and another sees it the other way. These things have to be truly undebatably erroneous. Disagreeing with how VA weighed evidence isn't enough. And I think I'm stealing your thunder here, Ethan.
That's okay. But that's exactly right. If VA looked at two medical opinions, for example, one's favorable to the veteran, one's unfavorable, they picked the unfavorable one. That's probably not going to be a cue because hypothetically, a reasonable person could disagree with which opinion to pick. And they might differ over the outcome there. It has to be really precise and specific about what VA did wrong. So you need to specify, did VA apply the law incorrectly? Did they ignore facts or evidence that was already in the file? Did they not give you a presumption that you were legally entitled to? It has to be framed correctly and specifically, or VA might just deny it on technical grounds. And that's really what makes these Q claims challenging.
Exactly. Another challenging type of claim, 1151 claims. These are essentially VA medical negligence claims. They're very difficult because you need to prove something that's sort of similar to tantamount to medical malpractice, but through VA's regulations and processes. So VA has their own regulation that governs what sort of burden you have to prove in order to be successful. So in plain English, you generally need to show that you have an additional disability caused by the medical treatment. It was caused by VA medical care, surgery, medications, or vocational rehabilitation. And it was due to negligence or an event that was not reasonably foreseeable in the conduct of that treatment.
What makes these so difficult is that they really require strong medical evidence. So that usually includes a private medical opinion that addresses what were the known risks of this procedure, what's the usual standard of care, and explaining why what VA did was so negligent or so unforeseen. VA will often argue that something was a known risk of a surgery or it wasn't caused by the VA treatment or just would occur naturally as part of the condition. So disproving that requires medical evidence directly, and getting that evidence can be pretty difficult for veterans.
Exactly. A next really difficult case can be if VA says that the presumption of soundness does not apply. What makes the presumption of soundness concept so difficult? This applies to your entrance exam and essentially the state that a veteran was in at the time they entered service. The law presumes that veterans who entered service were sound or healthy or without disability, except as to things that were specifically noted on entry. These are tricky cases because sometimes VA will deny service connection and say, we can't give you benefits for that. It didn't come from service. It pre-existed service. And that's where you might end up in a very sticky sort of legal theory world where you need to sort of unpack how the condition either did not pre-exist service, the presumption of soundness should apply, or even if the presumption of soundness doesn't apply, why you can still prevail in this type of case.
Yeah. And what really makes these challenging is that they're all about details. Having argued these cases at court and at VA, it's all about what was listed on your entrance exam, what happened in service, was it documented in service treatment records, or did you not seek treatment? What do examiners say about did your condition worsen in service or already exist before service? And that there are so many different factors there that can make these really difficult. A really common problem with these presumption of soundness cases is that VA will rely on medical evidence that is really weak or unsupported, just saying that your condition didn't get worse because of service, but not explaining why or what basis they have to make that conclusion. These cases can be winnable, and CCK has certainly won a good amount of them, but they require a lot of attention to detail, a lot of specifics, and a lot of focus on the entire history of the condition prior to service or during service.
Exactly. And on a similar theme, aggravation of pre-service conditions. These are really, really tricky. Again, because of the legal standard that applies, the presumption of soundness is sort of in play here too. So with an aggravation claim, a person's generally asserting that a pre-existing condition, a condition that existed prior to service, became permanently worse during service beyond what would have happened naturally in the context of that disability, such that service connection should be granted. And these are difficult because you all often need to establish a baseline, meaning that the condition was at a particular level of severity before service. You also need to show evidence of worsening during service beyond the natural progression of the condition, and a medical explanation that connects the dots. Why is the condition that you now have permanently worse because of in-service events? VA frequently denies these claims based on inadequate exams performed by VA contract examiners. Classic. They often do not do the in-depth review of medical records and the claimant's file to be able to determine the baseline and the in-service worsening that occurred that would provide a pathway to getting benefits.
So the evidence strategy for these claims really focuses on service records, lay statements describing what happened in service, medical opinions addressing the condition during service, really a lot of evidence explaining why why service made this condition permanently worse than it would have been otherwise, and why what happened to you in service was kind of the dispositive factor for the condition getting worse.
Exactly. Radiation exposure claims. Wow. This is just a list of all the hardest cases that we come across, but it's important to talk about them because these are tricky and complex, but like we mentioned before, they're not hopeless and they're not unwinnable. So specifically, why do I have such baggage with radiation exposure claims? These are really complex because they involve proving radiation exposure based on dose estimates. If you read the regulations about these, they're highly technical, very specific. So you need evidence that proves your claim, like specialized service verification. You need a medical nexus that links radiation to the disability that you're now claiming. And different rules can apply depending on the type of exposure, like atmospheric testing, Hiroshima and Nagasaki occupation, nuclear weapons work, or medical and industrial exposures. So there's all type of different radiation exposures that could occur. They have different rules attached to them. The dose estimates are complex, different units of measure than you've ever seen before. So these can be really, really technical cases.
Right. And they can often stall out or be denied as incomplete because VA will often get advisory opinions or request additional records or dosage estimates of how much radiation they think you received. Veterans are often going to need really specific evidence about not just where you served, but what your duties were that would have exposed you to this radiation. Proving that you got enough radiation doing these duties to be harmful, and you still need to prove a link between that radiation and your current disability. So you'll definitely want to review the regulation. That's 38 CFR 3.309, kind of learn about locations VA will automatically treat as causing radiation exposure. Like Mara mentioned, it is a really complicated regulation. Your eyes might start to cross reading it, but don't give up. There is a way to win these claims. You just need to be as specific and provide as much evidence in support of it as you can.
Totally. Next, we'll move on to protected work environment cases. A protected work environment case is one where we are usually helping a veteran secure TDIU or a total disability rating based on individual unemployability. But in a protected work case, the veteran is actually still working. But for their work in a protected environment, they would not be able to maintain a competitive job in the market, and they can be entitled to TDIU benefits despite that work. These are hard because VA tends to see things in pretty black and white terms. You either are working or you aren't. And if you are working, VA is not inclined to grant you TDIU. But a protected work environment is a very specific sort of middle point where, as I mentioned, the protections that your employer provides are the only things essentially that are keeping you employed, that are allowing you to engage in employment. And but for those protections, which are usually afforded to veterans by employers who have knowledge of their medical conditions, their service, and a lot of employers are also trying to help veterans by keeping them employed, by offering them a protected and highly accommodated job situation. But for all of that, you would not be able to work because of service-connected issues.
Yeah, what makes these cases really hard is that VA rarely concedes a protected work environment, like you said, but also there's not really a solid definition for what a protected work environment even means.
Yep.
It's determined on a case-by-case basis, and there's not one clean definition that fits all of these.
Yep.
What VA is really looking for is, one, the job is considered a lower income position. Again, there's not a clear definition of how much money that is, but they want it to be lower income. And second, that the accommodations you're getting from your employer are what they call unreasonable or above and beyond what an ordinary employer would provide. So even accommodations under the Americans with Disabilities Act might not be enough to show a protected work environment because those are pretty reasonable and standard. What they're really looking for, like you said, is that without these accommodations, the veteran would not be able to work in this job at all, not just accommodations that make it easier to perform the tasks.
And another key piece of these cases is getting employer evidence. We can't recommend that enough if you're fighting a protected work environment case. Really think about whether your employer can help to substantiate the unreasonable, extreme accommodations that they're providing.
Yeah, things like a write-up of your accommodations, your attendance records showing that you're allowed to leave or miss work, as needed. Exceptions to your performance, statements from your coworkers showing that you don't have to do things that all other coworkers have to do, what your earnings are, showing that you couldn't be competitive in the workplace without this job. It's a lot, and the burden is pretty high on the veteran to prove it, which means that VA oftentimes will really fight veterans on showing a protected work environment.
Exactly. Next up, we have PTSD stressor verification. So again, VA thinks black and white. And if you are asserting the occurrence of an in-service stressor that led to the development of a psychiatric illness in and after service, it can be very difficult to get VA to concede the occurrence of the in-service stressor without specific evidence that speaks to the fact that you were present during that stressor. Now, why is this difficult? Because VA will often refuse to admit that a stressor is verified. Stressors by their nature can be circumstances that are difficult to prove and that evade medical or even just paperwork, any documentation. So sometimes veterans will be present during service in a combat zone, and maybe VA will not concede that, but their lay testimony around what they experienced in service certainly does indicate the occurrence of a stressor. Another common example is with military sexual trauma. These are events that are often not documented, and so VA has a difficult time conceding and verifying the occurrence of a stressor, like an MST, in the absence of clear documentation, which I think is the crux of why these are tricky cases to win.
So a lot of times what these cases turn on is showing that there are some sort of marker or indication in service that VA considers a typical or common response to trauma or personal assault. This can be a decline in performance, an unexplained change in behavior, seeking STD testing, requesting to move units away from an assailant, or even showing that psychiatric symptoms began shortly after the stressor occurred. A big problem, though, as you mentioned, is that a lot of times survivors or people who have stressors don't report these at the time. It's only later that they even feel comfortable talking about it. So we see commonly that there are missing records or inconsistent exam findings, or something is not documented in the service records, and then VA not really considering your lay statement where you describe what happened to you in service. So these cases can absolutely be won, but they require, a specific evidentiary approach, especially if it's not documented in the service records. You'll need to look for other ways to support, that this stressor happened and that your behavior changed after it. And
now we'll move to the last tricky case on our list, which is earlier effective date cases pursuant to 38 CFR 3.156C. Personal favorite of mine. What makes these cases really hard to win is that there's a specific avenue in the regulation that says if you file for benefits for a condition and VA denies. We're often seeing this in the context of psychiatric conditions too. If VA denies and then years later they associate service department records, which is a very specific type of record, they have to come from the service departments, or be related to, like, be otherwise falling into the definition of a service department. If VA later receives service department records that were not of record at the time of the first denial and that were relevant to the claim or to the issue, then VA needs to reconsider in a way that sort of like reopens the older claim. These can be really powerful arguments in cases where a prior denial was not appealed. So there's no continuous pursuit chain going that would entitle a veteran to like an easy award of retroactive benefits if they win. So this regulation has the effect of allowing veterans to reopen a previously denied claim if service department records were later found, discovered, declassified, and associated with that veteran's file.
Yeah, and these cases are hard because they're just not very common. It's not often that VA misses a chunk of service records that already existed and fails to associate it with the file. And it really turns on the history of not just what happened to you in service, but VA requesting the records, VA overlooking a chunk of service records when they were added to the file, and, you know, kind of factual accuracy about what they show happened to you in service. So small errors in how VA does this can really change the outcome of a decision and push your effective date years back. But it is not a very common thing that we see, and it can be a pretty tough burden to show that VA missed part of documented service records, because, like you mentioned, generally that's one of the first things they request for a claim.
Exactly. So in closing, if you're pursuing one of these trickier, harder cases to win, Ethan had a lot of good tips. Focus on building the record strategically. Focus on supplying VA with the right documents they need, the right timeline, and specific medical opinions that really address the discrete issue that's involved in these cases. And again, we've said this a bunch of times today, but it's often worth consulting an accredited agent or attorney that can help you navigate the more specific, precise, and difficult legal burdens that apply to cases like these.